Your landlord does not own you. You pay your rent on time every month. You follow every rule in your lease. You take care of the property. And then your landlord walks into your apartment without warning, sends you a notice threatening a massive rent increase, refuses to fix the heat in the middle of winter, or starts making your life deliberately difficult after you dared to file a complaint. Sound familiar? Here is what most renters in the United States do not realize. Signing a lease does not give your landlord unlimited power over your life. The law gives tenants powerful, enforceable rights. And most landlords are counting on the fact that you do not know what those rights are. Welcome to Phase 2 of Rights in Reality USA. For the past 10 videos we covered your criminal rights, what police can and cannot do, your Fifth Amendment protections, your Fourth Amendment rights. All of that knowledge protects you in encounters with law enforcement. But what about the space where you live every single day? What about your home? Today we are covering the 6 most important legal rights every renter in the United States needs to know. Plain English, no jargon, no lawyers required. Stay until the end, because Chapter 6 covers a legal protection that most renters have never heard of, and it could be the most powerful tool you have. This is not legal advice, but it is legal knowledge. And today it could protect your home, your family, and your money. Let us get into it. Let us start with the most fundamental right every renter has in America: the right to a habitable home. This is called the implied warranty of habitability. It is a legal standard that exists in virtually every state in the United States, and it means your landlord is legally required to provide and maintain a rental unit that is safe, sanitary, and livable at all times throughout your tenancy. This is not optional. It is not negotiable, and it does not disappear because your lease says otherwise. What does habitable mean specifically? Your landlord must provide functioning heat and hot water, working plumbing and electrical systems throughout the unit, a structurally sound and weatherproof roof and exterior walls, freedom from pest infestations, rodents, cockroaches, bed bugs, functioning smoke detectors and carbon monoxide detectors where required by state law, secure locks on all doors and windows, and safe common areas if the building has shared spaces. If your landlord fails to maintain any of these standards, you have legal options, and you do not need an attorney to start using them. Here is exactly what to do when your landlord fails to make a required repair. Step 1. Put your repair request in writing every single time. A text message or email creates a legal paper trail. A verbal request does not exist in court. Step 2. Give your landlord a reasonable time frame to make the repair. For serious issues like no heat or flooding, this is typically 24 to 72 hours. For less urgent issues, 14 to 30 days is standard depending on your state. Step 3. If repairs are not made within a reasonable time, most states give you the right to withhold rent until repairs are completed, pay for repairs yourself, and deduct the cost from your next rent payment. Report the violation to your local housing authority or building inspector, or in severe cases, terminate your lease without penalty. Step 4. Document everything. Photograph the problem with your phone immediately. Note the date and time on every photo. Keep a written log of every communication with your landlord. This documentation is your legal foundation for everything that follows. This is one of the most commonly violated tenant rights in America, and one of the least understood. Can your landlord enter your apartment whenever they want? The short answer is no. In most states, absolutely not. In most states across the United States, landlords are required to give you advance written notice before entering your rental unit. The most common requirement is 24 to 48 hours advance notice. Some states require more. Very few require less. Your rental unit is your home, and the law treats it that way, with the same Fourth Amendment influence privacy protection we covered in Phase 1. The only recognized exceptions to the notice requirement are genuine emergencies: a fire, a bursting pipe causing flooding, a gas leak, or another immediate threat to life or property. In those situations, immediate entry without notice is legally permitted because the emergency justifies it. Outside of a genuine emergency, landlords are permitted to enter only for specific legitimate purposes, performing repairs or maintenance you have requested, conducting a scheduled inspection with proper notice, showing the unit to prospective tenants or buyers. All of these require proper advance notice and must occur at reasonable hours, typically during normal business hours on weekdays. Landlord entry rules: 24-48 hours written notice required in most states. Exceptions: genuine emergencies only. What your landlord cannot do is enter repeatedly to monitor your activities, enter to harass you or intimidate you, enter while you are away without providing notice, or enter at unreasonable hours, even with notice. If your landlord enters without proper notice, here is what to do. Document the unauthorized entry immediately in writing. Send your landlord a written notice, by email or certified mail, reminding them of the specific notice requirement under your state's law. Keep a copy of that communication. If unauthorized entries continue, you may have grounds to terminate your lease without penalty, file a complaint with your local housing authority, or in extreme cases, pursue a harassment claim. Every state has its own specific landlord entry notice law. Search the name of your state followed by landlord entry notice law to find the exact requirement where you live. Your landlord calls and says your rent is going up by $300, effective next month. Can they do that? The answer depends on three things: your current lease terms, your state's laws, and whether your city or county has rent control. Let us go through each one. First, your current lease. If you are in a fixed-term lease, meaning you signed a lease for a specific period such as 1 year or 2 years, your landlord generally cannot raise your rent until that lease term expires. The rent amount you agreed to in writing is the rent they must honor for the entire duration of that lease. Period. Any rent increase during a fixed-term lease without your written agreement is a breach of your lease contract. Second, notice requirements after your lease ends. Even after your fixed-term lease ends and you move to a month-to-month arrangement, most states require landlords to give written notice before raising rent. The standard notice period is 30 days for month-to-month tenancies. Many states require 60 or 90 days notice for significant rent increases. Third, rent control and rent stabilization laws. If you live in a city or state with rent control or rent stabilization, your landlord's ability to raise rent is legally capped. States and cities with strong rent control protections include New York, California, Oregon, New Jersey, Washington, D.C., and others. In these jurisdictions, landlords cannot exceed the legally permitted annual increase percentage regardless of what they want to charge. And in some cases, they must justify any increase to a rent board or housing authority. If your landlord raises your rent in violation of any of these protections, respond in writing within 30 days. State clearly that the increase is not legally valid under your lease terms or your state's law. Keep a copy of your response. Contact your local tenant rights organization or housing authority for further assistance. An illegal rent increase that goes unchallenged in writing can be legally treated as accepted. Respond. Always respond. Security deposit disputes are the single most common landlord-tenant legal conflict in the United States. And in the vast majority of cases, the tenant lost because they did not know their rights. Today, you will know them. Here is what the law says. Your landlord is legally permitted to deduct from your security deposit for the following: unpaid rent at the time of move-out, damage to the unit that goes beyond normal wear and tear, and cleaning costs if you left the unit significantly dirtier than its condition when you moved in. Your landlord is not legally permitted to deduct for normal wear and tear. Let me be very specific about what that means. Normal wear and tear includes small nail holes in walls from hanging pictures and art, minor carpet wear from everyday walking and furniture, small scuffs on walls from furniture, faded paint from normal sunlight and aging, worn areas around light switches and door handles. These are the expected results of someone living normally in a space. They are not damage. They are not your financial responsibility. and any landlord who deducts them from your security deposit is acting illegally. Beyond what can be deducted, your landlord is also legally required to return your security deposit within a specific time frame after you move out. In most states, this is 14 to 30 days. They must accompany any deductions with an itemized written list, clearly explaining every single deduction and the cost associated with it. If your landlord does not return your deposit on time, or makes deductions that are not legally permitted, you may be entitled to pursue the matter in small claims court. And in many states, the law allows you to recover 2 or even 3 times the deposit amount as a penalty for your landlord's failure to comply. Here is the single most important thing you can do to protect your deposit. On the day you move in, photograph and video every single inch of the apartment. Every wall, every floor, every appliance, every window, every fixture, every scuff, crack, and stain that already exists before you move in. Then, immediately send those photos and that video to your landlord by email. That email timestamp creates irrefutable legal proof of the exact condition the unit was in when you took possession of it. Do the same walkthrough on the day you move out. That before and after documentation wins security deposit disputes in small claims court consistently. Without it, your landlord's word carries as much weight as yours. If you have ever received an eviction notice or worried about receiving one, this chapter is essential. Here is the truth that many renters do not know. Your landlord cannot simply remove you from your home. Eviction is a formal legal process with very specific rules that landlords must follow, and significant legal protections for tenants at every step. Let us walk through the process. First, your landlord must have legal grounds to evict. The most commonly recognized legal grounds are non-payment of rent, a material violation of your lease terms, illegal activity occurring in the rental unit, or the natural expiration of your lease and a decision not to renew. Second, your landlord must provide you with proper written notice before beginning any formal eviction proceeding. This written notice is typically called a notice to quit or notice to cure. The required notice period varies by state and by the reason for eviction, but it is typically between 3 and 30 days. Third, if you do not voluntarily vacate after the notice period, your landlord must file an eviction lawsuit in court. They must go through the formal court process to obtain a judgment for possession of the property. What your landlord absolutely cannot do, under any circumstances and in any state, is change your locks without a court order, remove your belongings from the unit without a court order, shut off your utilities including heat, water, or electricity to force you out, or physically remove or threaten you to get you to leave. These actions are called illegal self-help evictions. They are against the law in every single state in America, and they expose your landlord to serious legal liability. If your landlord attempts any of these actions, contact the police immediately. Then contact a tenant attorney. Many cities have free tenant legal aid services, and in cases of illegal self-help eviction, you may be entitled to significant damages. You have the right to appear in court for your eviction hearing. You have the right to present a legal defense, and if your landlord failed to follow proper procedure, did not provide adequate notice, failed to maintain habitability, or is retaliating against you for exercising your rights, a judge may rule entirely in your favor. This is the chapter I mentioned at the beginning, and this legal protection, tenant retaliation protection, may be the single most powerful right you have as a renter, and surveys consistently show it is the right most renters have never heard of. Here is how it works. If you exercise any of your legal rights as a tenant, filing a complaint with a housing authority, reporting a code violation to a building inspector, organizing with other tenants to address building conditions, requesting legally required repairs, or asserting any right we have covered in this video, your landlord is legally prohibited from retaliating against you for doing so. What does illegal retaliation look like in practice? It looks like your landlord suddenly raising your rent shortly after you filed a complaint. It looks like a notice of eviction appearing within weeks of you reporting a habitability violation. It looks like your landlord refusing to renew your lease after you organized with other tenants. It looks like your landlord beginning a pattern of harassment or making your living conditions deliberately unpleasant after you asserted your rights. Here is the legal power behind this protection. In most states, if your landlord takes any negative action against you within 60 to 180 days of you exercising a legal right, the law creates a legal presumption that that action was retaliatory. The burden of proof shifts to your landlord. They must prove to a court that their action was not retaliation, not you proving that it was. This means that if your landlord attempts to evict you shortly after you filed a housing authority complaint, you can raise retaliation as a complete legal defense in court, and in many cases, that defense wins. The key to using this protection effectively is documentation. Every complaint you file, keep a copy with the date. Every repair request you send, keep a copy with the date. Every communication with your landlord, save it. Dates and timelines are everything in a retaliation claim. If you can show that negative action followed closely after you exercised a right, the law is working in your favor from the moment that case enters a courtroom. Retaliation protection laws vary by state. Search your state name, followed by Tenant Retaliation Protection Law, to find the specific protections and timelines that apply where you live. Let us bring everything together. Your landlord is legally required to maintain a safe and habitable home at all times under the implied warranty of habitability. Put every repair request in writing and document every problem with photos and timestamps. Your landlord cannot enter your apartment without 24 to 48 hours advance notice in most states, except in genuine emergencies. During a fixed-term lease, rent cannot be raised. After your lease ends, written notice is required before any increase. In rent-controlled areas, increases are legally capped. Your security deposit must be returned within 14 to 30 days of move-out with an itemized list of deductions. Normal wear and tear is never your financial responsibility. Photograph everything on move-in and move-out day. Eviction is a formal legal process requiring a court order. Your landlord cannot lock you out, remove your belongings, or cut your utilities without going through court. And if your landlord retaliates against you for exercising any of these rights, the law presumes retaliation and shifts the burden to them. Knowing your rights as a tenant does not make you a difficult renter. It makes you a protected one. This is video 11, the first video of Phase 2 of Rights and Reality USA. Over the next 5 videos, we are going deeping into housing law, covering the full eviction process step by step, illegal rent increases in detail, your security deposit rights specifically, landlord entry laws by state, and what to do when your landlord refuses to make repairs. If this video helped you, subscribe right now and turn on your notifications. We post a new legal rights video every 5 days. Until then, stay informed, stay protected, and remember, knowing your rights is your right.